There is a deed somewhere, filed in a county courthouse, printed on paper, bearing signatures and a notary seal, that says a piece of this continent belongs to someone. The deed references a survey. The survey references a prior deed. That deed references a treaty. And the treaty, if you follow the chain back far enough, references a doctrine so old, so embedded in the foundations of property law across the Western Hemisphere, that most lawyers have never examined it directly. It is called the Doctrine of Discovery, and it says, in essence, the first Christian European sovereign to discover land occupied by non-Christian peoples acquired by that act of discovery alone the superior legal title to that land. Now consider a different kind of claim to the same ground. A Lenape community along what is now the Delaware River did not record their relationship to that land in a deed. They recorded it in seasonal movement, in the paths worn by generations of feet between winter hunting grounds and summer fishing camps, in the names they gave to each bend in the river, each stand of particular trees, each place where the soil changed character, in the ceremonies that marked the first fish of spring and the last harvest of fall. Their relationship to that land was not ownership, it was something older, denser, and more specific than ownership. These are not just different legal systems, they are different understandings of what land is. The doctrine of discovery does not appear in most history textbooks, but its logic runs through the legal foundations of every nation in the Americas, Australia, and New Zealand. Its formal expression begins with a series of papal bulls in the 15th century. In 1452, Pope Nicholas V issued Dum Diversus, authorizing the Portuguese crown to invade, search out, capture, vanquish, and subdue all Saracens and pagans, and to take their lands and property. In 1493, 1 year after Columbus, Pope Alexander VI issued Inter Caetera, dividing the non-Christian world between Spain and Portugal and declaring that discovered lands were to be possessed by Christian sovereigns. These documents crossed the Atlantic with the ships. In the United States, the doctrine received its clearest articulation in Johnson v. McIntosh, decided by the Supreme Court in 1823. Chief Justice John Marshall wrote that the discovery of North America by European nations gave those nations, and subsequently the United States as their legal successor, an exclusive right to extinguish the Indian title of occupancy either by purchase or by conquest. Marshall was not inventing something new, he was codifying something old. The idea that indigenous peoples had a right to live on the land, but not a full legal title to it. That title, the real title, the transferable, alienable, sovereign title, belonged to the discoverers. From inside this framework, the logic feels airtight. Property requires clear ownership. Ownership requires a legal system to record and enforce it, and the only legal system the European courts recognized as legitimate was their own. So, if you are already inside that system, the conclusion seems to follow naturally. The land was legally available, it was settled, it was developed. That is how it works. Except that conclusion depended entirely on refusing to recognize what was already there. What was already there was not vacancy, it was jurisdiction. The Haudenosaunee Confederacy, the 6 nations of what is now New York and Ontario, had a constitutional system, the Guyana-Shigoa, or Great Law of Peace, that predates the European contact era and is widely acknowledged to have influenced the framers of the United States Constitution. It defined territorial relationships, responsibilities, and processes for resolving disputes between nations. The Anishinaabe peoples of the Great Lakes region organized their relationship to land through clan systems that assigned different families stewardship responsibilities over different territories, not ownership in the European sense, but accountable, inherited, spiritually grounded responsibility. These were not just informal arrangements awaiting formalization, they were governance systems, operating on their own terms, recognized by the peoples who lived within them, and sophisticated enough to have sustained complex societies across vast landscapes for centuries. The doctrine of discovery did not encounter a legal vacuum, it encountered legal systems it refused to see. The encounter between these frameworks did not happen as a clean debate between equals, it happened gradually through accumulated legal decisions, surveys, and administrative acts that each individually seemed like ordinary governance. Land was surveyed according to European conventions that treated it as a grid of abstract, interchangeable parcels rather than as a specific landscape with particular histories and relationships. Treaties were written in legal English or French or Spanish that encoded European concepts of succession and title, concepts that many indigenous signatories may not have understood in the terms the documents used. Court decisions built on prior court decisions, each one taking the previous layer of colonial law as its given foundation. The doctrine of discovery was the seed, administration was the soil in which it grew. By the 19th century, the framework was self-reinforcing. The United States owned its territory because it had purchased or conquered it from prior European claimants which had acquired it through discovery. The circularity was invisible from inside because every step in the chain was documented in its own language. What was not documented in that language was the prior system it had displaced. What was lost was not only land. The Anishinaabe names for specific water bodies along the Great Lakes encode centuries of ecological observation, the behavior of fish, the movement of weather, the location of safe crossings. Most of those names are not on modern maps. The Haudenosaunee oral tradition carried legal and diplomatic knowledge, the terms of alliances, the obligations of governance, the conditions under which decisions could be revisited. Some of it survived in wampum belts and in the memory of knowledge keepers. Some did not survive the disruptions of the 19th century. Across the continent, the ceremonies that marked human relationship to specific landscapes, that embedded people in a place and reminded them of their responsibilities to it, were suppressed by law and by institutional pressure. In Canada, the Indian Act of 1876 banned the potlatch and other ceremonies. In the United States, the Code of Indian Offenses of 1883 made traditional religious practices punishable by withholding of rations and imprisonment. You cannot ban a ceremony without also suppressing the knowledge that ceremony carries. And yet, the Haudenosaunee Confederacy still meets. The Great Law of Peace is still recited. Potlatches returned after the ban was lifted in 1951 in Canada. Indigenous land defense movements invoke Indigenous law, not as historical memory, but as present legal reality. The older system was not erased, it was pressured, and pressure is not the same as erasure. In 2005, the Oneida Indian Nation raised the Doctrine of Discovery directly before the United States Supreme Court, arguing that the doctrine was a product of a racist colonial era and should no longer be treated as valid law. The court did not rule in their favor. In 2023, Pope Francis formally repudiated the papal bulls of the 15th century, declaring that the Doctrine of Discovery is not part of the teaching of the Catholic Church. The repudiation was significant. It was also, as many Indigenous legal scholars noted, not legally binding on any court. The doctrine lives not in the Vatican, but in the property records and court decisions of every nation in the hemisphere. To remove it would require not a statement, but a systematic re-examination of the legal foundations on which land title across the Americas currently rests. That re-examination has not happened. In some places, it has begun. Return to the deed in the courthouse. It still sits there in its filing system, referencing a survey, referencing a prior deed, referencing a treaty, referencing the doctrine. And somewhere, a community still knows the name for the bend in the river that the survey line crossed without stopping, still holds the memory of whose responsibility that ground was and what it was responsible for producing. This was not progress replacing ignorance, it was one legal system overriding another, and then insisting for centuries that the system it overwrote had never existed. The question before us is not whether to undo history, it is whether to finally read it accurately. This is before America. If you want to understand the legal ground beneath your feet, not just who owns it, but how that ownership was constructed and what it replaced. Stay with us. There is much more to examine.